the judgment and hopefully the sentencing of Mike Chimombe as well as Moses Mpofu, who are basically punished for exposing the rot in the government of Emmerson Mnangagwa. Under normal circumstances, these two individuals, I'm not saying they are good when it comes to issues of looting. They are also found wanting, but them to be trialed alone without Wicknell Chivayo, their business partner who was also involved in corruption. And I think their crime to Emmerson Mnangagwa specifically and his courts, it is exposing Wicknell Chivayo as well as Mnangagwa and some government officials like Mnangagwa himself, the first lady in Zimbabwe, the wife of Mnangagwa, and also the chief of staff of Mnangagwa, they were implicated by these individuals, and that is why today you find them in court. I think for just a moment we would be listening at the judgment that is ongoing. I think it is obviously what the regime may do. They may opt to punish them. Already they have been imprisoned for the longest period of time. Let's just listen to the judgment proceedings.
The ministry to act to its prejudice. The name was invalid, was not supposed to be used, but it was used all the same. Could it be said that the intention was to bring about prejudice? In view of what appeared to be common cause and what the witness said, we believe that the names were used, as I said, to add some color to them, but not really that the ministry would be deceived as to the entity it was dealing with. The ministry was not deceived. It was dealing with Electric Private Limited. The award was made, although names were used interchangeably, different names were used interchangeably, but the letter from Praz is clear that it was being awarded to Electric Private Limited. And in fact, the money was dispersed to private. So clearly, in terms of who it was dealing with, the ministry was not deceived. We are therefore not satisfied that although the state proved that black-tail livestock and poultry farming was not registered as the name of any company, we could not infer that the use of that name was meant to disguise or distort or confuse. I mean to deceive the ministry as to the registered entity that it was dealing with. Because then documents that were submitted were the Certificate of Incorporation of Black Private Limited, the CRA 16 of Black Private Limited, the CRA 14 of Black Private Limited, and as I've already said, the ministry dealt. The state of mind of the ministry, as deciphered from the witnesses, was that they were dealing with Black Private Limited. So, what the state proved, as I've said, that the name was not registered, would not have sufficed as, would not have sufficient to constitute. But the matter does not end there. The state alleged other forms of misrepresentation, which are that the Zimra tax clearance submitted to the bid was counterfeit, and that the NASA compliance certificate submitted to the bid is counterfeit, and that the performance of the contract was going on well, which was intended to induce the ministry to part with funds. In other words, the state says, false statement was made that 32,500 goats had been gathered, when in fact that statement was false. It was one of the series of acts which were committed for the purpose of inducing the ministry to part with funds. It had that potential prejudice. clearly at the end of the trial, as submitted, as testified to by one of the state witnesses.
A judge that is not even reading the judgment is just...
Black Deck Private Limited or the accused persons had not placed before this court evidence that, contrary to what we saw on the tax compliance certificate, which would mean that the companies were not tax compliant because they would have relied on fake documents. The company was in fact tax compliant. As regards the NASA compliance certificate, proof was there in the fact that the Black Deck Private Limited had been deregistered, and there was no.
Why don't you?
Apart from the mere sense of the person that he saw certain reports that payments were being made. We believe that the failure by the first accused person to call the witness that he intended to call affected his credibility, affected his defense. These were witnesses that he considered necessary, even as he knew at the beginning of the state case that he was being charged in his personal capacity. He knew that these witnesses were important material to his defense as he was being charged in his personal capacity. They were indeed, because he had to extricate himself from a criminal conduct for which the company could be charged. His decision not to call these witnesses was his own, for reasons best known to himself, except the explanation that we received that one of the witnesses had died, which explanation was not verified in the usual way by the production of proof of the existence of that witness and the death of that witness. Ordinarily, which should be the case in this case, where a litigant threatens to call witnesses to confirm his or her defense and later abdicates or fails to call that witness, the usual inference is that probably there was no serious intention in the first place to call that witness, or that the accused, the litigant realizes that if the witness is called, he will not confirm the position taken by the litigant. In other words, where one is promised, undertaken, or of their own volition to call a witness to confirm their case, and they abdicate from doing so, adverse inferences can be drawn from such conduct. And in any event, that affects the assessment of the credibility of their evidence. The explanation given by the accused, first accused, is that he did not have to call the witnesses because he realized that he was being charged in his personal capacity. That explanation is not convincing at all. This is because, as I have said, when he gave his defense outline, he knew that he was being charged in his personal capacity, but he considered that the witnesses were important. So at what stage did he change his mind? Did he consider that those witnesses would not be relevant to his evidence? Well, he insisted that he was not being charged in his capacity as a representative of Black Deck Private Limited. That was the submission by Mr. Koto, who said the charge specifically alleged that he is personally liable because he's a director of, he did the acts in his capacity as the director of a company which would have been liable to be charged. We do not agree with that submission We also do not agree with his understanding of criminal liability as created in section 277 of the Criminal Law Codification and Reform. We have already referred to the South African case, where the South African court expressed reservations about the applicability of the corporate veil in cases involving fraud and other cases of dishonesty. We have already said that that was the common law which expressed those reservations. We have already said that subsequent to that, our law was codified. Clearly, the codification of 277 was to deal with that mischief, was to conflict the director and the company, in the sense that because the company is not.
I've never seen such this judgment is long. I was hoping it's coming to an end.
It's just a person.
Let's just stay on
in
for
the eyes
some
of the
few
law.
minutes.
The term that is usually used is that it is a juristic person or a fictional person which is then given certain capacities at law as if it were a natural person. It's really not a person created by God as we know the natural person. It is a person created for the purposes of conducting business. And then it is given certain capacities which are attributed by law of persons to capacities.
It's been almost 2 hours this judge speaking like this.
It being a fiction, you can't touch it. It does not have a brain of its own. It does not have a mind of its own. It does not have a soul of its own. It does not have limbs of its own. It conducts its business through the agents of natural persons. So it's very difficult to separate the acts of a company from the acts from the board which makes decisions on behalf of the company. And that's the whole, in our belief, that is the whole essence of section 277. Section 277 deals with criminal liability of corporations and associations and their members, employees, and agents. Subsection 1 defines director. Director in relation to corporate body means a person who controls or governs that corporate body, whether lawfully or otherwise. Or is a member of a board or a group of persons which controls or corporate body, whether lawful or otherwise. This company was controlled by a board. The first accused person was the member of that board. So he was the director of it. Subsection 3 says, where there has been any conduct which constitutes a crime for which a corporate body is or was liable to prosecution, that conduct shall be deemed to have been the conduct of every person who at the time was a director or employee of the corporate. I just pause there to record what we meant when we said we differed with Mr. Koto's interpretation. He said the corporate body must be charged with the accused person for personal liability to attach. I don't know where he's getting that. We would accuse him of rewriting the law because subsection 3 is unambiguous. It says, for which a corporate body is or was liable to prosecution. That is not the same thing as saying for which a corporate body is being prosecuted. A corporate body would have been liable, but the state may decide not to charge the corporate body. That does not defeat the prosecution of its director, who provided his limb, who provided his soul, who provided his mind, in the actions giving rise to the criminal conduct for which a company could be charged. The court recognizes the independence of the Prosecutor General to institute prosecution. We are aware from the published prosecutorial guidelines that the Prosecutor General considers the sufficiency of evidence test and the public policy test. That is a public document which was published by the Prosecutor General in terms of the Constitution. So the court takes judicial notice of that.
This case
So the state may decide not to prosecute, but that does not absolve a director, as I've said, who provided his amenities to if it is shown that he provided his amenities in the offense. And such a director is liable personally if his conduct was accompanied by the intention on the part of the person responsible. The person responsible in the company. This is the natural definition of a crime. If you look at the beginning of the Criminal Law Codification Act, any person is not liable unless certain acts and omission which constitute criminal conduct are proved against that person, and unless it is shown that the requisite state of mind, criminal state of mind. So there's nothing really spectacular about this, except that it really says any director who does, where a company is liable to be charged or was liable to be charged, this director can be charged or is also liable. The fact that one is a director gives rise to that liability, which can only be escaped by resorting to the proviso to that section, subsection 3 of section 277. It says, provided that if it is proved that a director or employee of the corporate body took no part in the conduct, this subsection shall not apply to it. That is very critical. The first accused person must have been aware of his obligation to extricate himself from this situation. Where is a director of a company that submitted a bid which contained a falsified tax clearance, which contained a falsified NASA compliance certificate? That act then becomes his, unless it is shown, it is proved that the director, which means him, took no part in the conduct. That must have informed his decision to call witnesses who are going to show that he was absent when all these things were happening. He then decided not to call those witnesses. The question is onus. Who has the onus to show that he took no part? Is it the accused person who is charged or the state? Section 18 is helpful. In any event, invariably, where a presumption gives rise to criminal liability, and the person charged, which means would be the first accused person, relies on a proviso as his defense that he did not. At the very least, he has the onus on the
why do you have to think while you wrote a judgment?
Standard.
And this is very primitive.
That he did not take part. The state does enough when it proves the criminal conduct of a company for which he is a director. Then such conduct is presumed to be his. Now, when he wants to escape liability or conviction, he must then demonstrate, which is simply what onus means. Onus is that duty to place before facts, the facts which demonstrate or prove, which are enough for that defense or that position to succeed. Subsection 5 says a person who is criminally liable in terms of subsection 3, which I've just been reading, shall be liable to be prosecuted and punished personally for the crime. So there are a submission that he should not be prosecuted personally in circumstances where criminal liability arises and clearly is not correct. The first accused person was also aware of the provisions of the law, which, as I said, cited the Companies Act, the Companies and Other Business Entities Act, which say a director who is involved in dishonest behavior cannot be absolved, cannot be hanged in corporate crime. They also refer to subsection 385 of the Criminal Law Codification. Sorry, the Criminal Procedure and Evidence Act, Chapter 907, subsection 7. Which we say it is possible for the accused in criminal procedure to charge this personal person.
I've never seen it. The judgment
when the company and the accused and its director are charged together with the conviction of crime, they are co-accused persons. They are each liable for conviction if the state proves they are not separately. In other words, but that doesn't. In other words, the company will still be guilty, and the director can escape liability if he fulfills the requirements of the proviso to subsection 3. This person is only charged. It is not correct that an accused person is charged in a representative capacity. No, that may be confusing, and that may be what confused Mr. Porto. And in terms of procedure, section 385.3, we've already said the company can be touched. It has incorporeal personality. It can be touched, so it can be in the door. So in terms of section 385 of subsection 3 of the Criminal Procedure and Evidence Act, in any proceedings against a corporate body, a director or employer shall be cited as representative of that corporate body.
Well, I have to. It appears it's not going to end. I think I will come back to you and most probably do a specific short live broadcast to actually see how all this ended. That was the judgment that is currently being handed down. It's already 6:12. You can see that this judge is deliberately taking his time. He could have actually read the final judgment and unveiled the rest of how he arrived to that particular judgment for the lawyers of the accused, so that they can present that information to the accused. But from the look of things, the judge wants overtime. The judge wants to deliver this over a period of 2 days. If we are lucky to get the final verdict as well as maybe sentencing, we will be able to bring this live to you. As I've said, this is a case of two gentlemen And we know they are being punished by Emerson Tambutso Mnangagwa for exposing corruption and rot in his administration. Because if this was a sincere prosecution, it should have included Wicknell Chivayo. Thank you very much for watching us. If you're watching us for the very first time, please do remember to press the red or black subscribe button so that next time when we beam live, you become the very first one to watch us.